Hello and welcome to today's program, Digital War, the military response to cyber threats and the future of cyber warfare. This program is brought to you by the ABA Standing Committee on Armed Forces Law and the ABA Young Lawyers Division Government, Military, and Public Sector Lawyers Committee. I am Joe Allers, the YLD liaison to the Standing Committee on Armed Forces Law, and I will be your moderator here today. Before we begin our presentation, please let me note that our speakers are all employed by the United States government, and for our audience today, the views expressed in this webinar are the views of the speakers alone and not necessarily the views of their respective military service, the Department of Defense, or the Department of Homeland Security, or the United States government. Forbes magazine declared 2017 the year of cyber warfare. The United States is investing vast resources into cyber operations and participating in global exercises like the NATO organized cyber defense war game, and experts have opined that actors like North Korea have a much more likely chance of attacking foreign states with cyber weapons than with traditional ones. And in fact, states like North Korea may have played a role in the WannaCry malware crisis that occurred just a few weeks ago. In this continued and complex environment, how does the United States military take offensive and defensive measures to protect the safety and security of the United States while still following applicable laws and regulations? And even a bigger question, how do those laws change based on whether we're fighting against an organized terror network, an adversarial foreign country, or an individual hacker? How about if the person that's perpetrating that attack is a United States citizen? The individuals working in this complex and evolving area of law face these questions on a daily basis, and we have three experts here to talk to you about just those things. Our first speaker is Lieutenant Colonel Greg Stricker. He is the Deputy Staff Judge Advocate at U.S. Army Cyber Command, Fort Belvoir, Virginia. U.S. Army Cyber Command directs and conducts integrated electronic warfare and information and cyberspace operations as authorized or directed to ensure freedom of action in and through cyberspace and the information environment, and to deny the same to our adversaries. Lieutenant Colonel Stricker's areas of responsibility, including providing legal counsel on cyberspace operations and command policy. With that, I'll turn it over to Colonel Stricker.
Joe, thank you very much. And thank you to the ABA for having us on this webinar regarding digital war. This is an area of law which is developing yet is firmly based in our U.S. national and international law. Like Joe mentioned, I'm Lieutenant Colonel Gregory Stricker. I'm the current Deputy Staff Judge Advocate for U.S. Army Cyber Command. And if I may comment on that for a moment, as an Army Judge Advocate, I have been able to work in several core legal disciplines, and none has been more vibrant than the application of law to the cyber world, whether it's intellectual property, tax law, privacy, criminal law, or international law. That's in part why working in Army Cyber Command has been such an intellectually challenging and interesting experience. In my capacity as Deputy Staff Judge Advocate, I provide legal counsel on, among other things, cyberspace operations. So Army Cyber Command is an Army unit, and when ordered, the command's mission is to direct and conduct cyberspace operations to ensure DoD's freedom of action and to not deny the same to our adversaries. So before my command conducts cyberspace operations, a contextual issue to consider for policymakers, of course, is considering whether the actions conducted in cyberspace against our nation or against others, perhaps, will be considered a use of force or an armed attack against the state. As we go along through this discussion, let's consider a spectrum of state cyber actions from minimal to the more damaging and destructive. There are a wide array of actions nation states may conduct against each other's interests. Some actions may simply be the manipulation of networks for intelligence purposes. Such actions might copy information without damaging the functionality of the networks or systems. Nations commonly conduct these types of intelligence operations of this nature as traditional state activities. Next on that spectrum of cyber actions, consider cyber actions which may deny access to information, services, or the loss of data. This in turn may be very limited to completely blocking the use of those services. But finally, on the far spectrum, we consider actions which may be of significant damage, serious physical injury, or even death. For international law purposes, when we consider the actions of one state against another, we can consider it in the context of the UN Charter. At the end of the Second World War, in an effort to prevent further carnage, the signature states of the UN Charter attempted to end the possibility of future offensive war between states. The Charter goes on to prohibit uses of force which affect national integrity or sovereignty in Article 2.4, and it defines armed attack as a circumstance when national self-defense would be authorized in Article 51. So when we consider the spectrum of nation-states' actions, would intelligence activities in cyberspace be considered a use of force? If information is solely collected, does this impinge the territorial integrity or the sovereignty of the state? Or is this simply the type of intelligence collection which nation-states normally conduct? What about the denial of service or deliberate destruction of data? Is this a use of force impinging national sovereignty? And finally, and most severe, cyber actions which cause serious injury and loss of life. Is this considered a circumstance authorizing state self-defense? When considering the factors, we may also consider the instrument of the action and the effects of the action. Does the instrument used distinguish itself as a use of force, armed attack? For example, in a physical sense, the use of a firearm or inherently a deadly instrument. Is there a cognizable example in cyberspace of such an instrument? Or should we consider the nature of the effects in determining if this is a circumstance in which states may defend themselves? Following the cyber incidents in Estonia and Georgia in the last decade, a group of international experts came together under the auspices of the NATO Cooperative Cyber Defense Center of Excellence, and together considered if international law applies in cyberspace, and specifically for this discussion, jus ad bellum for cyberspace. Specifically, they sought common understanding of the relationship between cyberspace operations and how they would relate to potential interstate conflict. Subsequently, in 2016, Talon 2.0 has been published after the Talon 1.0 was published in 2013 to consider the broader scope of international law and its wider relationship to state cyberspace operations beyond armed conflict. But back regarding the earlier work of Talon 1.0 from 2013. In describing the state of cyber war, Professor Michael Schmidt of the U.S. Naval War College, a key figure in both Talon manuals, described factors to consider for determining the use of force armed attack in his December 2012 Harvard International Law Review article discussing the soon-to-be published at that time Talon 1.0. Professor Schmidt reiterated the work of the Talon group of experts. The factors for consideration serve as context for the nature of considering those types of incidents. Those factors for consideration of determining whether something is a use of force include severity, immediacy, directness, invasiveness, presumptive legitimacy, measurability, and responsibility as factors to be considered by the receiving state as to whether the state can act in self-defense. The first factor in this effects test, severity. What is the scope and intensity of the effect? It's important to note, it is possible the severity of the effect from a cyber operation may be so extreme, the only ways that it outweighs and makes irrelevant the remainder of the effects test. That being said, let's consider the other factors. The next factor to consider is immediacy. How quickly are effects felt? Is it possible for a cyber effect to not be immediate? Of course. But the experts consider this relevant as to determining the use of force in the totality of the circumstances. The next, directness. Were the state's actions the proximate cause of the effects? Did the cyber operation directly cause the injury to the state, or was it somehow attenuated? The next factor, invasiveness. Does the cyber action cross into the target state's sovereign territory? Measurability. How do you quantify and measure the effects? What information was collected to determine those effects, and what's your validity and your understanding of the information you've collected. Next, presumptive legitimacy. Is there a domestic and international acceptance of this type of action that was made against the injured state? Has the action achieved something, the acceptability under customary international law? The final factor to consider on this test is responsibility. Can it be attributed to a specific state? And frankly, that can often be a very difficult determination, as we've seen in the press. This test provides a useful method for understanding the nature of an event and if its context rises to the level of a use of force or an armed attack. In considering the basis of use of force and armed attack and self-defense, it's important to understand the U.S. position on these issues. The longstanding U.S. position has been that a use of force and an armed attack may be synonymous for U.S. self-defense. In 2012, Dr. Harold Koh, then the General Counsel for the U.S. State Department, stated, "In our view, there is no threshold for use of deadly force to qualify as an armed attack that may warrant a forceful response." He noted that some nations consider an armed attack as having higher threshold before the right of self-defense is triggered. In his remarks to U.S. Cyber Command in 2012, Dr. Koh sought to state the U.S. position on the use of force in cyberspace. Dr. Koh reiterated that certain actions could constitute a use of force or an armed attack in cyberspace. He states the U.S. definition of a use of force in cyberspace constituted cyber activities that approximately result in death, injury, or significant destruction, which would likely be viewed as a use of force. Or as he further stated, if the physical consequences of a cyber attack work the kind of physical damage that dropping a bomb or firing a missile would, then a cyber attack should equally be considered a use of force. This policy on cyberspace use of force and armed attack has been reaffirmed as recently as January 2017 by the DoD General Counsel. So after the analysis, what if we don't have a cyber armed attack? What is the nation state to do? The range of the responses is noted by Brian Egan, the General Counsel for the State Department last year in a speech at UC Berkeley, may include such things as economic sanctions or declaring representatives persona non grata. Additionally, he discussed countermeasures, which is also discussed in the talent manual. Countermeasures could be considered by an injured state for internationally unlawful acts conducted by the injured state, or conducted by the injuring state. Countermeasures are actions which normally would be considered unlawful under international law, but are permitted solely as a responsive action to an injuring state. The injured state needs to consider the following. Number one, have they ensured they have attribution before embarking on countermeasures? 2, they must comply with the principles of necessity and proportionality. 3, they must only be addressed against the injuring state. And 4, they must be preceded by demanding the state resume respecting international law. States must be careful when embarking on countermeasures, as their actions may be violations of international law if they misattribute or fail to otherwise comply with these principles. So in summary, international law applies to state action in cyberspace, and states do have the ability to respond both with to an armed attack and unlawful state actions which fall below the use of force. One additional issue to consider is the concept of cyber weapons. If such an instrument is developed, it should be reviewed for compliance with the international law, and its employment should comply with the law of armed conflict principles of military necessity. Its use should be discriminate, proportional, and preventive of collateral damage. Joe, once again, thank you for having me here. I look forward to the questions at the end of the session, and I believe the next up is Ms. Lively. Thank you.
Thank you, Colonel Stricker, for that helpful background and analysis on the frameworks in this area of law. As a reminder for those who are joining us late, please type any questions you have into the chat function, and we'll answer them at the end of our presentation. Ms. Rebecca Lively is our next speaker. She is the Chief of Cyber Intellectual Property Law for the 67th Cyberspace Wing Legal Office at Joint Base San Antonio, Lackland. She serves as the primary legal advisor for the Staff Judge Advocate to the 688th Cyberspace Wing and oversees all areas of cyber intellectual property law for both the 67th Cyberspace Wing and the 688th Cyberspace Wing. These two wings train and employ airmen to conduct offensive and defensive cyber operations and exploitation, as well as full-spectrum network operations and systems security assessments for the Air Force, Joint Task Force, and combatant commanders. Ms. Lively, the floor is yours.
Thank you very much, and I'd also like to echo Lieutenant Colonel Stricker's sentiments. Thank you for having us and allowing us to speak on this topic, which is hopefully interesting, although perhaps not quite as sexy as a lot of people expect it to be, especially when you're lawyers rather than the actual folks doing the operations. As Joe said, I represent both the 67th and the 688th wings. Those are the two primary wings in the Air Force who do cyberspace activities. The primary three lines of effort are very similar to how the Army sees it. We both operate our network, we defend our network from adversaries, and then we engage adversaries as appropriate under international law. Couple of comments before I start. These are my views. These views do not necessarily represent the Air Force or the Department of Defense. I also promise you I'm not sharing any classified information with you. So if you are hearing something that's super exciting, you are free to contact me and I will tell you exactly what open source place it came from, or I will tell you while I'm talking about it. Also, I have 15 minutes to cover what is probably each slide could be a course, a law school course in and of itself. So forgive me if I both go very quickly. I'll try to not do that. And two, speak very generally. What I will try to do is give you sources as I go, where if you're curious about this or want to learn more, you can go kind of as a first look. So with that, I will get started. My first topic area is very similar to what Lieutenant Colonel Stricker covered, so I will go quickly. The biggest thing to think about if you are interested in international law as applied to cyberspace is to take a look at the Talon manual that Colonel Stricker mentioned. The Talon 2.0 was just released. It is fairly comprehensive. It's very interesting if you find this sort of thing interesting. And it really does give a very good overview of the considerations of international law as applied to cyberspace. One of my very strong opinions is there really isn't such a thing as cyber law, and there really isn't such a thing as cyber war. There's just law and war, and you apply those things to cyberspace or apply cyberspace to that, but you don't actually need to have a special domain or a special set of rules per se for those things, or at least not for most of the aspects of those things. Another good resource for the especially nerdy is the Lawfare blog. If you Google it, you will find it, and it talks often and frequently about cyberspace topics. And then I will cover a little bit later the Stuxnet virus, but there is a somewhat recent book and a documentary related to that book that recently came out called Countdown to Zero Day that is also very interesting if you are interested in these sorts of things. So when thinking about international law, some of the considerations that we think about are sovereignty, jurisdiction, and then LOAC considerations. So generally, with regard to those three lines of effort that I mentioned, these apply most frequently when we're either engaging an adversary in some way, or in some cases when we're defending our network, specifically if we're reaching beyond the borders of our network into either commercial space in the United States or external to the United States. With regard to sovereignty, generally it's accepted that a state has territorial jurisdiction over anyone in their space, in the state being in this case a nation. Cyber activities that are either originating in or completed in the state's territory, or cyber activities which have a substantial effect. Having territorial jurisdiction isn't necessarily enough if you do not have enforcement jurisdiction. So a great example of that is there's been a number of indictments recently that the United States has issued against cyber actors in various states. And as you may have noted, there have been no corresponding trials for those indictments. And that is because China is not exactly eager to send us their citizens to try here. So it's kind of an interesting situation when it comes to jurisdiction, but it's also one of the reasons that you will hear a lot of cyber lawyers ask questions about where various pieces of computer equipment are located, and why a lot of our analysis has to do with that physical location. So you may have a server that is located in a friendly nation that appears to be attacking the United States, and we may happen to know that the actual, state actor who's involved is some third country, and it can create a very difficult jurisdictional question as to how exactly we go about stopping it. I think espionage and the law of armed conflict were pretty adequately covered in the last discussion. Basically, being espionage is the sort of a gentleman's agreement between the states that we're all going to do it, and it's fine. And LOAC is something that we obviously need to do the appropriate analysis of at the appropriate time. The only issue with espionage is it can be really hard to tell the difference between what are preparatory actions for espionage, so getting into the computer to steal state secrets, versus preparatory actions for some sort of more aggressive act. So that can be kind of challenging, but that is the job of all of our analysts to figure out, as well as attribution, which can be exceptionally difficult in cyberspace. And I think in that way, it's one of the biggest ways that what happens in cyberspace is very different than other areas, because generally, when it comes to a kinetic war, you know whether or not you're being attacked pretty much immediately when it starts. Domestic law considerations generally apply most frequently when we are operating the Air Force network, and to a limited extent when we are defending it. Again, often it gets kind of murky in the defense of our network. Obviously, the United States Constitution is this giant document y'all have probably all heard of. Super important when it comes to what various people's or what our rights are as U.S. citizens and what binds state action. We can't, unreasonably search and seize things and all of that. So when it comes to running our own network, we need to ensure that our actions are consistent with the Constitution, especially when it comes to monitoring communications and things like that. Also, the Electronic Communications Privacy Act, which encompasses the Wiretap Act, the Pen Register Trap and Trace Act, and the Stored Communications Act, go and give additional protection beyond what the Constitution provides. And so it's vital also that our actions on our network be consistent with that. The Computer Fraud and Abuse Act is another one that sometimes tangentially applies, or at least where we definitely need to do some analysis. And that basically prohibits exceeding authorized access to an information system, to a protected information system. If you are interested in a very robust, thorough analysis of these issues as applied to running a government network, if you Google the Einstein 2.0 legal memo, it's a little bit dated, but it's actually still surprisingly interesting and relevant to the type of analysis that we need to do before we can do monitoring on a government network. The last primary topic that I'm going to cover real quick is contracting for cyberspace tools and support. This is one of the biggest challenges that we have in cyber operations, both offensive and defensive. There are lots and lots of laws applying to the government as to how we can contract for services. Generally, we have to have full and open competition where we advertise what our requirement is. We receive bids. We generally, any limitations on who we can advertise to or receive bids from must be fully justified and usually approved at a very high level. And as a result, we're pretty much advertising most of our requirements on a public-facing website, which all of our adversaries can and I'm sure do read on a regular basis, which makes lots of people nervous when it comes to contracting. In addition to that, because of the process of advertising, defining requirements, advertising them, receiving proposals, analyzing those proposals, potentially receiving bid protests, we're tied to a pretty lengthy cycle, which when it comes to cyberspace makes it really, really hard to have the newest, coolest tools because we had to plan for them 3 years in advance and they didn't actually exist then. So that's a huge challenge, and it's one that I think the community is working very well to tackle, but it's not solved yet. One of the ways we tackle that full and open competition advertisement issue in the cyber realm occasionally is with classified contracting, where we have exceptions that allow us not to, advertise our most sensitive requirements. But even that can come with its own challenges, specifically with regard to things like bid protests and Court of Federal Claims issues related to the award of the contract, because none of that is actually exempted just because the requirement is classified. So you could end up with a situation where you go through lengthy classified litigation, and that is not only burdensome, slows down the process, but is also just logistically extremely difficult. So it's something that we try to avoid when we can, although a lot of times it's just not possible. Finally, there's intellectual property and ownership challenges. So the general rule is that if especially a small contractor, but usually a large contractor as well, creates something even within the scope of a government contract, they're entitled to keep the title to that creation, and the government generally, if the contract has been done right, is entitled to a perpetual royalty-free license to use that. Other types of intellectual property can apply, so sometimes there's situations where a contractor brings something that they developed externally. So there can be a lot of challenges with cyberspace tools, which are protected by all sorts of different types of intellectual property. There can be a lot of challenges there in making sure we get what we actually are intending to get, we get the rights that we're intending to get, and we're getting it in a way that doesn't restrict us to a single contractor. These are all of these issues kind of bundle into what can be kind of complicated and unfortunately also somewhat dense as far as the subject. The Federal Acquisition Regulation is not a thrilling read, and so people sometimes, especially our clients, get frustrated by the many onerous requirements that they have to go through just to get what they believe they needed like 6 weeks ago. They would like to get it 6 weeks from now, and that can be extremely challenging. So the last thing I want to give you guys is a couple of real-world examples and just sort of my own views and opinions on where we're going as far as cyberspace stuff goes. So first I will hit the very quick what's next. I think one of the things that we'll see in the near future is an increased focus by the government on cyber deterrence, similar to nuclear deterrence. The way that we do cyber deterrence I don't think will be similar to nuclear deterrence, but I think having an increased stance with regard to having effective responses to cyberspace actions and having the ability to ensure that, well, basically that there's too high of a cost to breach either our data or to conduct a cyber attack in the United States. I also think that we will see outsourcing of day-to-day network operations. So next time I give this brief, perhaps I will not be talking about how we actually operate and run the Air Force network, and increased reliance on the cloud, so to speak. The risk, of course, there are risks there, but I think there are also a lot of benefits. And then I think we'll also see increasing flexible acquisition authority. So in the latest NDAA, there was some increased flexibility for what's called other transaction authority that allows us to kind of test out cyberspace tools in real time and then have flexible authorities to purchase the winner or the best product directly without going through additional competition. So that's where I think we're going. A couple real-world examples that I think have been pretty widely reported in the news for the most part. I just want to go through really quickly. So the OPM data breach, as most of you are likely aware, there was a huge breach of data related to pretty much everyone who's ever worked for the federal government. There were a lot of public or reporting statements that this was a huge cyber attack. I don't call it a cyber attack. I think it was some pretty exceptionally well done espionage, which, as Colonel Stricker said, is generally an acceptable thing. It's certainly a very good example, though, of how we need to improve our cyber hygiene and our cybersecurity as a government, because it's also totally unacceptable, even if it was not necessarily a true cyber attack. The alleged Russian interference with the U.S. elections, if you haven't heard about that, I have no understanding of how that's possible, because it is all I've heard about on every single news station for the last, I don't know, 3 or 4 months. But again, that is something that I don't personally think rises to the level of an armed conflict in any way. I don't think there's really a good argument that it does. But it certainly violates international norms. And I think that's a great example of where the U.S. government has used countermeasures similar to what Colonel Strecker's discussed in his example. Stuxnet is another one you hear about a lot, which is the worm that attacked or that went after Iranian centrifuges. And that one is just a good example of something that I think by some definitions could potentially rise to that level, as it caused real-world damage to actual physical things that you could touch and look at. The final one I just want to tell real quick, because I think it's a neat cyber action that has been publicly discussed. It's called Operation Cupcake, and this is another one that it's a great example of how we can use cyber capabilities in the international realm, but not necessarily in ways that would otherwise constitute an arms attack. With Operation Cupcake, the British intelligence authorities and cyber dudes basically went into a Al-Qaeda website where they were publishing bomb-making instructions. It was called How to Make a Bomb in the Kitchen of Your Mom, and replaced it instead with cupcake recipes, which I just thought was exceptionally clever, and so I like to use that example every chance I get. But with that, I think I have used all of my time. I look forward to any questions that you'll have, and thanks again for letting me talk.
Great, thank you, Ms. Lively. We're going to turn next to Lieutenant Commander Jeremy Weiss. He is the Acting Deputy Chief of the Office of Information and Intelligence Law at U.S. Coast Guard Headquarters, where he provides legal counsel to Coast Guard intelligence and cyber command leadership. Lieutenant Commander Weiss is a Coast Guard Academy graduate and served as a deck watch officer and later in the Domestic Port Security Evaluation Division before receiving his JD from the George Washington University School of Law in 2011. Lieutenant Commander Weiss, the floor is yours.
Thanks, Joe, and thanks very much for this invitation and opportunity to talk. I think I really welcome the opportunity to provide a slightly different perspective, just given the Coast Guard's unique role. And so, so just I guess first off, the Coast Guard, obviously our missions are unique among the armed forces. While we absolutely maintain a warfighting capability, our day-to-day missions are more typically law enforcement or maritime safety or search and rescue. And so I think that informs a lot of our perspectives as far as what how we approach cyber operations and how we exercise our authorities. So because we're a small organization and a lot of people don't really know what the Coast Guard does, I wanted to go over some of our main authorities. And so first off is our core law enforcement authority, which is pretty broad when you take a look at it. The Coast Guard, it says, can make inquiries, examinations, inspections, searches, seizures, and arrests upon the high seas and waters over which the U.S. has jurisdiction for the prevention, detection, and suppression of violations of laws of the United States. And so When you take a look at that, it gives the Coast Guard a pretty broad authority to board vessels, conduct searches, make seizures, in enforcement of U.S. federal law. And accompanying that is some case law that has pretty well established that the Coast Guard is able to conduct those searches and seizures on board vessels without a warrant, as long as we are following the standard reasonableness tests under the Fourth Amendment, except in the case of where we're on the high seas dealing with aliens to the United States who don't have a direct connection, where law has said that the Fourth Amendment is not necessarily going to apply. And then our second core authority is that the Coast Guard is at all times an armed force. So under Title 10, the Coast Guard is included in the definition of armed forces. And so I will conveniently incorporate everything that Colonel Stricker and Ms. Lively said before as far as the legal framework for international cyber operations, and kind of bootstrap the Coast Guard into that as far as our authorities go. As an armed force, the Coast Guard certainly has the authority to engage in national defense operations, and that includes operations in cyberspace, and we actually have Coast Guard personnel serving within U.S. Cyber Command. Additionally, something people may not know is that the Coast Guard is a member of the intelligence community. So the Coast Guard has authority, like other members of the intelligence community, to collect intelligence, to analyze, produce, and disseminate foreign intelligence and counterintelligence for national defense purposes, as well as to support national and department missions. And finally, the Coast Guard has a broad regulatory role in the areas of maritime transportation and maritime safety. And so when I look at cyber operations, I'm thinking of how the Coast Guard is applying our authorities within the cyber domain. And so in 2015, the Coast Guard Commandant came out with the Coast Guard Cyber Strategy, which focused the Coast Guard's efforts in where we're going to exercise our authorities within cyberspace, and the Commandant defined three major priorities. The first was defending cyberspace, and within that were the goals of identifying and hardening systems and networks, understanding and countering cyber threats, and increasing operational resilience. And then the next priority was enabling operations. And then the final priority is protecting infrastructure. And so each of these areas had a number of objectives which present their own legal challenges as far as applying the Coast Guard's authorities. In defending cyberspace, some of those legal challenges are looking at how we're going to respond to threats to the Coast Guard network. They also include how we develop our cooperative agreements with both other agencies within DHS and with DoD to provide a robust defense of our network. And the final one is how we conduct our operations both within the Coast Guard network, and as we develop our abilities, how we're conducting operations to actively defend against threats. Within enabling operations, again, some of the challenges are how our existing intelligence and law enforcement authorities translate to cyber operations, and whether there are any gaps or areas where we need to ask for additional authorities to effectively operate within our core missions. And then finally, within protecting infrastructure, some of the issues are how we implement our information sharing, whether it's voluntary or compulsory with industry. Again, so when we're talking about protecting infrastructure, we're talking about protecting the maritime transportation sector, which the Coast Guard is the sector-specific agency for. So how we protect cybersecurity vulnerabilities within that sector, and how we exercise our regulatory authority in that sector, whether we adopt a approach similar to how the DHS NCIC, the National Cybersecurity and Communications Integration Center, how they have more of a voluntary reporting model where industry can voluntarily report vulnerabilities and receive assistance, or are we going to act in more of a compulsory way where we require the reporting of vulnerabilities and incidents? And another question is whether we need additional regulation to effectively accomplish that mission. Most of the port security regulations that the Coast Guard acts under were implementing statutes that were passed in the early 2000s, and so obviously technology has changed quite a bit, and some of those regulations may not have addressed in as much detail as we would want now what sort of security measures we'd like facilities and vessels to be taking. So to implement that Commandant Cyber strategy, I just wanted to briefly highlight, because our the Coast Guard Cyber Commander has published lines of effort in order to identify what he sees as the immediate activities that the Coast Guard will take to further those further that strategy. And so briefly, those lines of effort include establishing the Coast Guard as the recognized leader for cybersecurity in the maritime transportation sector, organizing command and control for Coast Guard cyberspace operations, developing and building Coast Guard cyberspace workforces aligned with the DoD model, generating the first Coast Guard operating forces for cyberspace, including an integrated network operations security center and a cyber protection team that is organized, trained, and equipped at joint DoD standards. And finally, modernizing the Coast Guard networks and IT systems into a command and control, computers, communications, cyber, and intelligence enterprise mission platform. So I mentioned a little bit earlier, but what are some of the legal challenges that arise when the Coast Guard, which is traditionally a law enforcement and national defense agency, is exercising our authorities in cyberspace? The first is, within defending cyberspace, are we leveraging the Coast Guard authorities to ensure that that Coast Guard Cyber Command has the tools necessary to protect networks and to work with DoD and maintain consistency and interoperability? Within protecting infrastructure, some of the challenges are partnering with our maritime transportation system stakeholders, whether that's facility operators or port authorities, and developing a regulatory framework that is workable and is going to be robust in addressing both industry concerns and what our concerns are as far as cybersecurity. So finally, what does all this mean in practice? I think I liked what Ms. Lively said as far as there is no cyber law or cyber war, it's just law or war. And I think that's very apt because we are applying the same authorities that we have always had in a rapidly and dynamically changing environment. The laws are not necessarily keeping pace with how technology has changed, especially in the areas of law enforcement that we see as far as just kind of an example. In many jurisdictions, things like pagers were considered fair game under search incident to arrest, right? There's a lot of different rationales for that, whether it was because of exigent circumstances or whether the information on that pager was perishable, because if you got so many different phone calls into the pager, you could actually lose phone numbers from the older parts of the memory. And then suddenly, as technology advanced, courts became less and less comfortable with law enforcement searching things like cell phones, and finally we see the Supreme Court deciding in Riley v. California that things like smartphones are not covered under that exception to the warrant requirement. So that's definitely something that we see in the law enforcement context. I think as far as the fact that there is no cyber law, I think if the more that you bring an understanding of constitutional law and admin law and criminal law and privacy law, international law to the table, you really see pieces of everything coming in on a day-to-day basis. For instance, if you're working with your network defense operators and they want to implement a new technique, or they want to increase security and in conjunction with that change the AIS agreement that all the government employees are forced to sign. Well, you can do your analysis of all those activities that they're going to do, as far, from the Fourth Amendment standpoint and everything else. And then, for instance, you may have someone come in and say, well, I just got a call from the union representative, and they don't like that we're going to have to sign this new AIS agreement. And so understanding the complexities involved there go a long way. Another example is in the Coast Guard's traditional mission of port security. Let's say, for instance, you want to conduct a survey of the port to find out how robust the security for wireless networks is within port infrastructure. If you were just surveying physical infrastructure, that's pretty simple. But you suddenly encounter things like the Electronic Communications Privacy Act, Computer Fraud and Abuse Act, where you have to be very careful about what you're doing and how you do it, and in order to make sure that you are following the law as far as conducting your operations that you see that you need to do to protect the port. So I think my time is up, and I just want to say thank you for this opportunity, and I look forward to any questions there might be.
Thank you very much, and thank you to all of our panelists. We have just a few minutes for questions, and I'm going to start with a question for any of the panelists. Individuals with specialized skills in this area are being recruited and well paid by government contractors, private companies, the individuals who are actually carrying out these cyber duties for the military. And for the military, there's fixed pay scales. It takes months, maybe years of required training to get people through the process. How does the government compete for talent in this environment?
Well, this is Lieutenant Colonel Stricker. I'll take that one, and then we'll see if Ms. Lively's got any comments on it. That is a huge challenge in this field. We have, cyber is the defining, I think, growth sphere for technology and how we apply science to business today. And I think we've really reached a point where it is challenging for the government to hire folks. But to be frank, that's been the same way for probably about the last 20 years. It's challenging to hire folks in the government service. I will tell you that the folks that I work with on a daily basis, whether they're contractors or they're government civilians or they're military, they have a sense of duty, they have a sense of commitment, and that's why they've decided to pick this field to work in. We are looking at ideas for how we can better incentivize folks to stay with us or to come into our ranks, but I think that fundamental sense of duty to the Constitution and to what we're to the country we're trying to defend is really key to the folks that we get. Thank you.
I agree completely. The only thing I would add is I think the work that you do if you work for the government is often a lot more interesting than the work you would do if you worked in the private sector. And also, we have exceptional and robust training programs. So folks, frankly, want to come to work for the Air Force or the DoD to get all of the good training and then go and be extra competitive when they go work for contractors and make about twice as much down the road. So I think those are two reasons we see a lot of people come in. And so long as we can hold on to them long enough after they've got their training to get some benefit out of it, I think we'll continue doing okay, even though we can't really compete as far as salaries go.
Great. Thank you both. Our next question is a little long. I'm going to read it. It says, can you conceive of a cyber attack or cyber attack coupled with another operation against a fundamental structure like an election of another nation constituting a use of force? And so is a cyber attack coupled with something else perhaps constituting a use of force? And the second part of the question, is the perception of the victim's state of severity of the attack an important factor in determining whether a response against the attacker is warranted?
Yeah, so this is Lieutenant Colonel Stricker again. Yeah, once again, very challenging fact pattern, and I would say that I would strongly recommend you take a look at the Schmidt factors, because for each nation state it's going to be different in interpreting their priorities when we look at those factors. So the first factor is severity. What's the scope and intensity of the effect? And then you look at another one that would be key to this is invasiveness. How much does this attack the sovereignty of the state itself in a physical sense? Those are definitely key things to consider. But I think Ms. Lively, I think in my personal view, not speaking for DoD or anybody else, I think Ms. Lively has accurately described this as probably something, that kind of level of activity likely falls below the concept of use of force, armed attack as we would interpret it in the U.S., in which self-defense would be authorized. Now, could the concept of countermeasures be used? I think that's probably definitely something that is worth considering. What types of countermeasures? They must be proportional and so I think we definitely have to consider countermeasures. But when you consider countermeasures, you've also got to make sure that you have appropriate attribution. You've got to have attribution, because if you fail to attribute it to the correct party and you take a countermeasure, those actions themselves could be unlawful. Thanks.
The only thing I would add to that is, just because it doesn't constitute a use of force, and thus we cannot, under international law, in my opinion, respond with a use of force, doesn't mean that under the idea of countermeasures we can't do things that would otherwise be considered to violate international law. To include, I mean, almost every cyber operation that you can think of doesn't constitute an arms attack, in my opinion. So I think there's a lot of flexibility in response options that are not off the table just because it's not technically an armed attack.
Thank you. We got a question about the recording of this webcast. So just to remind everybody, all registered attendees will receive a link to the recorded webcast after it's complete. I've got one final question, and I'm going to send it to Lieutenant Commander Weiss first. What's your assessment of kind of the on-the-ground application of some of the stuff we see in the movies, where somebody's holding an iPad and they can start controlling an enemy's aircraft or a submarine, or maybe, for instance, in the Coast Guard, where there's a big mission off the coast for drug interdiction? Is that sensationalized? How close is the reality of our capabilities, of course, without going into anything classified, that these are real concerns for the cyber community?
Wow, you really laid a minefield for me there. I got to be careful. I think it's a mix. I think we're getting closer to science fiction every day. Certainly, a lot of very significant capabilities are things that you can download off of the Apple App Store, as far as gaining information about your electronic environment. So I think you can extrapolate some of that and say that the capabilities that the armed forces have might be slightly better than that, but yeah, I think that's as far as I will say.
All right, thank you. That is all the time we have for questions and for our webinar today. I'm Joe Allers, and on behalf of the ABA Standing Committee on Armed Forces Law and the ABA Government, Military, Public Sector Lawyers Committee, I want to extend a very big thank you to our three panelists, Lieutenant Colonel Stricker, Ms. Lively, and Lieutenant Commander Weiss, for joining us and providing us your expertise today. And with that, thank you for joining us, and please have a wonderful day.